Hey, welcome to the Vernacular Vault. Today, we're going to talk about something we all kind of take for granted, a right that just feels ancient, fundamental. We're talking about the right to privacy.
I mean, think about it. We're constantly worried about who's watching. Government surveillance, big tech tracking every single click, our private chats getting leaked. We fight tooth and nail to protect our privacy because we're sure it's this essential human right that's always been there.
But what if it wasn't? What if I told you the entire legal idea of a right to privacy, the simple concept that you have a right to be left alone, is actually super recent, like shockingly recent? What if it wasn't dreamed up by some ancient philosopher, but was instead a direct response to some crazy new technology from the late 1800s? All right, let's get into it. To really understand where our modern idea of privacy comes from, we gotta jump in the time machine and head back to the late 19th century. And you'll see it was a time of technological chaos that honestly feels a lot like our own. So try to imagine this. You're living in a world where, for the first time ever, someone could snap your picture in an instant without you even knowing, and then, bam, it's on the front page of a newspaper for thousands of people to see. That was the brand new and kind of terrifying reality created by two big inventions. First, you had the portable Kodak camera, basically the 19th century version of a smartphone. And second, you had the explosive rise of what they called yellow journalism, which was this new sensationalist press that was hungry for gossip, scandal, and, pictures of private citizens. All of a sudden, your life wasn't really your life anymore. Well, this new reality really bothered a couple of Boston lawyers. One was Samuel Warren, and his law partner was a guy you may have heard of, Louis Brandeis, who would go on to become a legendary Supreme Court justice. They were just fed up. They were seeing the private parties and family gatherings of Boston's high society getting splashed all over the papers, and they realized the law had absolutely no way to deal with this new kind of harm. So they did something about it. In 1890, they wrote this absolutely game-changing article for the Harvard Law Review. It was called, simply, The Right to Privacy. And in it, they made a powerful case. New technology means we need new rights. They gave this new right a name so simple and so perfect, it stuck with us for over 100 years. The right to be let alone. Okay, so having a brilliant idea in a law review is one thing. But how do you get that idea, this right to be let alone, to actually become a real legal protection? Well, that journey took a while, and the first steps were, let's just say, very literal. For decades, the courts basically saw privacy through this lens called the trespass doctrine. A 1928 Supreme Court case, Olmstead v. United States, really cemented this. The government had put a wiretap on a bootlegger's phone lines, but, and this is the key part, they did it from the street. They never physically stepped onto his property. And the court said, hey, that's fine. Your privacy wasn't about your conversation. It was about your property line. No physical trespass, no search, no problem. It was that simple. But there was one voice on that court who strongly disagreed. And who was it? None other than Louis Brandeis, the guy who helped invent the whole idea in the first place. In his now famous dissent, he basically warned everyone that technology was leaving the law in the dust. He wrote that the government can now find out what is whispered in the closet without ever kicking down the door. It was this incredible forward-thinking warning that, believe it or not, took almost 40 years for the rest of the country to finally listen to. And that brings us to the moment when Brandeis's vision finally won. And it's all thanks to a bookie named Charles Katz and a regular old public phone booth. So it's 1967. The FBI thinks this guy, Charles Katz, is running an illegal gambling operation. They know he uses a particular phone booth to place his bets. So what do? They stick a listening device to the outside of the booth. See, they were being clever. They didn't trespass, they didn't break in, and they argued in court using that old Olmstead rule that since it was a public phone booth on a public street, Katz had zero right to privacy. And right here, this is where the tectonic plates of privacy law shifted. The Supreme Court did a complete 180. They threw out the old trespass rule. In a now famous line, the court declared that the Fourth Amendment protects people, not places. Think about that. Even though Katz was standing in a glass box on a public street, when he closed that door, he had a reasonable expectation that his conversation was private. And from that moment on, the law protected that expectation, not just a physical property line. But how do you decide what's reasonable? Well, that's where Justice Harlan came in. In the same case, he came up with a simple two-part test that courts have used for decades. He said you have a reasonable expectation of privacy if, One, you actually acted like you wanted it to be private. You closed the door. And two, that expectation is something that society as a whole would agree is reasonable. This simple test became the blueprint for how we think about surveillance, even today. So we've established privacy from government snooping, but that's just one kind of privacy, right? What about our right to make our own personal decisions without the government sticking its nose in our business? Well, for that, the Supreme Court had to get a little poetic. They found it hiding in the shadows of the Constitution itself. This next big case is called Griswold v. Connecticut, and it has nothing to do with wiretaps. It's about a very old, very strange law in Connecticut that made it a crime to use any form of contraception, even if you were married. Estelle Griswold, who ran a Planned Parenthood clinic, basically challenged this law head-on and got herself arrested. Now, the court had a problem. The word privacy isn't actually written anywhere in the Constitution. So where does this right come from? Their solution was pretty brilliant, actually. They argued that if you look at a bunch of the rights that are in the Constitution, like freedom of association, the right to not have soldiers in your home, the protection from unreasonable searches, they all cast what the court called penumbras, or shadows. And when all those shadows overlap, they create a larger zone of privacy. It's this idea that all these specific rules point to a bigger, fundamental right to be left alone in your personal life. Justice William O. Douglas put it perfectly. He asked rhetorically, would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? He said, the very idea is repulsive. And, he's right. Some things should just be private. But here at the Vernacular Vault, we believe in being very public with our appreciation. So if this explainer is giving you a new way to look at things, maybe take a private moment to hit that very public like button, subscribe, and ring the notification bell. It really lets us know we're on the right track. So why are we digging up this 130-year-old story? What's the point? Well, it's because the legal tools that were created in these historical battles are the exact same tools we're trying to use to make sense of our crazy digital world today. That zone of privacy from the Griswold case, that became the direct legal foundation for Roe v. Wade. And that reasonable expectation of privacy from the Katz phone booth case, that's at the center of every single debate we have about cell phone searches, email snooping, and digital surveillance. Together, these ideas even form the basis for later decisions on private relationships, like in Lawrence v. Texas. This invented right, it became one of the most important legal concepts of our time. It's kind of amazing when you think about it. It all started with two lawyers annoyed by gossip columnists and nosy photographers. And from that one complaint, this entire legal framework was born that has shaped the line between us and the government for over a century. Every single argument we have today about facial recognition, social media, or AI, it's just the next chapter in the story that Warren and Brandeis started writing way back in 1890. Which really brings us back to their original question, just with a 21st century twist. In an age where we are constantly connected, constantly tracked, constantly sharing, what does it actually mean anymore to be let alone?